Hello, everyone, and welcome to Internet Law Review. For today's story, we have the United States Supreme Court case of Food Marketing Institute versus Argus Leader. This is a case dealing with the intersection of the public's right to know under the Freedom of Information Act, as well as a private person's right to keep confidential details confidential. In this factual situation, what happened is people provide information to the government, and then later another person wanted to obtain that information from the government. So the operative question here is, when that information was provided to the government, does it become public information that must be disclosed, or does it remain private information? So let's take a little bit closer look at the facts and see what the United States Supreme Court decided. Let's get started. Respondent Argus Leader Media filed a Freedom of Information Act request with the United States Department of Agriculture seeking the names and addresses of all retail stores that participate in the National Food Stamp Program, which is also known by its formal name as the Supplement Nutrition Assistance Program, SNAP, and each store's annual SNAP redemption data from fiscal years 2005 to 2010. So we're seeking the information as to who is participating in this and also how much people are redeeming at each store. The USDA declined to disclose the store-level SNAP data, invoking the Freedom of Information Act's Exemption Number 4, which shields from disclosure trade secrets and commercial or financial information obtained from a person and privileged or confidential. Argus Leader sued the USDA. Following circuit precedent, the district court employed the competitive harm test, under which commercial information cannot be deemed to be confidential unless the disclosure is likely to cause substantial harm to the competitive position of the person from whom the information was obtained. The court agreed that revealing store-level SNAP data could work some competitive harm, but it could not say the disclosure would cause substantial competitive harm and thus ordered disclosure. Petitioner Food Marketing Institute, a trade association representing grocery retailers, intervened and filed an appeal. The Eighth Circuit affirmed, rejecting the Institute's argument that the court should discard the substantive competitive harm test in favor of an ordinary public meaning of the term confidential. So I thought it would be helpful to talk a little bit about what intervention is. This lawsuit started out with a private party suing the United States Department of Agriculture. The United States Department of Agriculture lost in the trial court based on circuit precedent. Apparently, the USDA decided not to appeal. However, an industry trade association wanted to intervene, that is, become a party to the lawsuit because this information would hurt its people. So I thought we'd talk a little bit about the rule that allows it. So this is rule number 24 of the Federal Rules of Civil Procedure, which guides when intervention is appropriate. So there's intervention as a matter of right and intervention which can be permitted. So under the federal rules, you can intervene as a matter of right if a federal statute says you can, or if you have claims, an interest relating to property or transaction that is the subject of this action. Alternatively, the court may give you permission to intervene if there's a conditional right in a federal statute, or if you have a claim that shares with the main action a common question of law or fact. So for the United States Supreme Court, there's a couple of issues for them to resolve. First, does this trade association have the right to intervene? This goes to an issue called standing. In order to have an issue resolved by a court, you must have standing. That is, you personally must have a sufficient injury to bring the complaint to court. So first, the question is, does this trade association have this kind of standing? Are they being injured by this decision so that they have standing to raise the issue? And then subsequent to that, assuming they do, the next issue is, should they win? Should the circuit court be overturned as to its precedent, and should the case law be changed so the more common meaning rather than the technical meaning is adopted? Let's see what the Supreme Court had to say. Held. The Institute has standing to appeal. Disclosure of the contested data would cause its members some financial injury in the highly competitive grocery industry. This concrete injury is directly traceable to the judgment ordering disclosure, and a favorable ruling from this court would redress the retailer's injury by reversing that judgment. Where commercial or financial information is both customarily and actually treated as private by its owner and provided to the government under assurance of privacy, that information is confidential within Exemption 4's meaning. At the time of the Freedom of Information Act's enactment, the term confidential meant private or secret. Contemporary dictionaries suggest two conditions that might be required for information communicated to another to be considered confidential. When the information is customarily kept private, or at least closely held, by persons imparting it, and when the party receiving that information provides some assurance that will remain secret. At least the first of these conditions must be met. It's hard to see how information could be deemed confidential if its owners share it freely. But the court need not resolve whether both conditions are necessary because both conditions are clearly met here. Uncontested testimony established that the Institute retailers customarily do not disclose store-level SNAP data or make it publicly available. And to induce retailers to participate in SNAP and provide store-level information, the government has long promised retailers it will keep the information private. Early courts of appeals confronting Exemption 4 interpreted its terms in a way consistent with these understandings. Argus Leaders pins its hope on the substantially competitive harm requirement from the D.C. Circuit's decision in National Park versus Conservation Association versus Morden. There, the court inappropriately resorted to legislative history before consulting the statute's text and structure, and relied heavily on statements from witnesses in congressional hearings years earlier on a different part of the bill that was never enacted into law. Unsurprisingly, National Parks has drawn considerable criticism over the years, and even the D.C. Circuit has distanced itself from the decision. Argus Leaders' attempt to salvage national parks is unpersuasive. First, it rearranges the text of Exemption 4 to create a phrase that does not appear in the statute, confidential commercial information. It then suggests that this synthetic term mirrors a pre-existing common law term of art that only covers information whose release would lead to substantial competitive harm, but points to no treatise or case decided before Exemptions 4 adoption that assign any such meaning to the term actually before the court. Nor will this court ordinarily imbue statutory terms with specialized common law meaning when Congress itself has not invoked the common law terms of art associated with that meaning. Alternatively, the company suggests that Congress effectively ratified its understanding of the term confidential by enacting similar phrases in other statutes in the years since National Park was decided. But the ratification canon applies when Congress reenacts the same statute using the same language, and Congress has never reenacted Exemption 4. Finally, Argus Leader urges this court to adopt a substantially competitive harm requirement as a matter of policy because it believes the Freedom of Information Act exemptions should be narrowly construed. But this court cannot arbitrarily constrict Exemption 4 by adding limitations found nowhere in its terms. Gorsuch wrote an opinion on behalf of the court, which all 9 members of the court joined. 3 members of the court did file a dissent in partial dissent. So, as to the main part of this opinion, it can be viewed as a 9-0 unanimous court decision. On the whole, I believe the Freedom of Information Act should be understood to require disclosure of information. However, where information is solicited by the government as private and confidential, the government should respect that privacy. We as the people ultimately have the right to determine what information should be given to the government and have the right to determine if that information should be public. But under this particular situation, this exemption covers trade secrets, and the government provided a trade secrets type assurance the information will be kept confidential. Information relating to redemptions of SNAP data can be used by competitors to extrapolate general sales data, and therefore would give competitive edges, so I perfectly understand the policy reasons for keeping this information private. On the whole, I agree with this decision, as it follows the exemptions set up by Congress both as to its text and to its intent. But until later, my friends, this is Bonal. I hope you're well. Until later, cheers and goodbye.